and welcome back to LawTorn, the podcast that explores what really happens when family fights turn into legal battles. My name's Samara Dutton. I am a partner in the private wealth disputes team, and I am joined, as always, by Philippa Dolan, a partner in our family team. Hello, Philippa.
Hello, Samara.
And we thought that today what we would be chatting about is the really quite interesting, although in many cases very sad, topic of predatory marriage, because it does sort of cross over our two areas of practice quite conveniently, in that obviously it deals with marriage, but also with issues around capacity and often wills, etc. So I suppose the easiest way to start is just to give some idea of the sort of normal fact pattern where you're faced with a predatory marriage situation, which is basically that an individual who is vulnerable for some reason, whether they have sort of learning disabilities or they're more elderly and they may have lost some of their cognitive abilities, some of their capacity, somebody in that situation is sort of targeted and pursued by someone normally of the opposite sex, but not necessarily, I suppose, who is
up to no good,
has some ill intent, and basically sort of persuades them or just manipulates the situation such to engender a relationship with them, and often sort of will then isolate them from their other family members or friends, other people that care about them, and sort of sneak off and secretly marry them. And other friends, family members may not be aware that that's even happened. And then commonly what happens is that after this sort of vulnerable, usually elderly person passes away, you find out that this marriage was in place, and that as a result, any will that this person had from years back when they did have the capacity to make a will has been revoked. And what ends up happening is that the spouse, the new spouse, the sort of person with the ill intent, inherits the lion's share of the estate, whether under an intestacy rule or because they've also managed to persuade said person to create a new will in their favour.
Tell me what revoke means.
Well, I mean, this is part of it. I mean, that's the fact pattern. So you have sort of a person who is vulnerable to exploitation, being exploited, a relationship develops. There may or may not be a secret marriage. There usually is. Well, obviously in the predatory marriage arena, there will have been a secret marriage, or not necessarily a secret. But really, the problem is not with what happens factually, but with the legal framework surrounding that fact pattern, which is a sort of intersection of rules relating to capacity and rules relating to marriage and rules relating to wills and testamentory wishes, etc. And where they come together, it just seems to have made a huge God almighty mess, which allows these kind of predatory marriages to take place, because there is a rule, I believe it's in one of your statutes, isn't it?
Well, not
your but it's part of the Marriages Act, isn't it? But yes, there's a rule that says any marriage will revoke a pre-existing will, and that means that the will disappears. It's as if it never existed. So as soon as you get married, any will that you've previously made now means nothing, is not worth the paper that it's written on. And if you don't make a new will, then you will, and then you subsequently pass away, you will die intestate, and your estate will pass according to the laws of intestacy, which may not be what you wanted at all.
Being when you haven't got a will.
Is exactly what it means, that you don't have a will, and therefore there is a statute that will govern how your estate is divided and who gets what.
Which is not, it's not a mad system, I mean, on the whole, it tends to, if you die without a will, it sort of follows what most families would probably want to do anyway, which is go, first of all, to children, then to parents, then to brothers and sisters. So
it does, but where there's a spouse, which obviously is the issue in the type of things we're talking about, the spouse gets a big piece of the pie before anybody else gets a look in. Which, as you say, in a number of circumstances, what you want.
And even the idea that it removes any will you've made, because people do get married, are really excited, forget they've got a will. Most people would want to leave part of their estate to their new partner at least, if not all of it. And so it's based on with good intent. It's just that
the intestacy rules are logical. They're sensible. I've got no particular gripe with them. but it is the intersection of that with this provision that any marriage will revoke a will that you have in place. That I think is not widely known. If you're not a lawyer, it's where on earth would you learn that?
I know. So, tell us what is planned to try and improve that situation.
Well, so I mean, it doesn't stop there actually, because it's about the differing capacities as well, isn't it? So the major issue around the sort of predatory marriage is that marriage revokes a will, but in order to get married, there's a much lower bar. Like so you often have capacity tests about whether or not something you're doing is a valid act. Did you have capacity to get married? Did you have capacity to make a will? If you didn't, then either of those things can be invalidated. But the test for capacity to marriage, to get married, is based on the Mental Capacity Act and is completely different and much lower hurdle than the capacity that you need in order to make a proper will. So you can revoke a will by getting married validly and with capacity at a point when you couldn't actually make a will, and that's it's sort of incongruous.
And this great quote from Nicholas Mostyn, family judge, which is, the wisdom of a marriage is irrelevant. And I thought it says so much, doesn't it? People who get married and all their friends and family are going, oh no, but you can marry who you like, but only if you know that you are marrying them. Yes,
and that you want to, presumably. But in any case, so it's that sort of disconnect between the capacity tests for the two things that is really frustrating here, because why should somebody without capacity to make a will be able to revoke a will, which has the opposite effect what you would want them to do, by getting married? And so it's that, and then also the laws around marriage. So if they do, and I will come on to answer your question, which was what's being done to address it. But I think I'd like to sort of dwell on all the problems with it to begin with, because if you do get married, and if you are then able to show that actually I didn't even have capacity to get married, because obviously if you have got married, then later on your family potentially are going to want to challenge the validity of that marriage if you are someone who really doesn't or shouldn't have had capacity. But so, I mean, marriage is a bit more your area than mine. Like, how does that work? How easy is it to challenge the validity of a marriage of somebody where somebody has been sort of manipulated into doing it?
Well, I've learned a lot just looking this up. I mean, I know very little about the laws of marriage, I've realised, rather than all the practicalities of getting divorced. And, it's interesting, and obviously a lot of it goes back a long way. But if you want to get out of a marriage other than by divorce, then there are avoidable marriages, there are void marriages, and there are a marriage that effectively was a non-qualifying ceremony. Now, and they're all different. So, for example, avoidable marriage or instances of where you can get out of the marriage because it's voidable is where it hasn't been consummated owing to physical incapacity, hasn't been consummated, i.e. you haven't had sex after the ceremony owing to the willful refusal of one of them, that either party didn't validly consent to it, which is often when it comes into these elderly, vulnerable people, probably, whether because of unsoundness of mind is the phrase or otherwise, that the respondent was suffering from VD in a communicable form at the time.
At the time of the marriage.
And that one of them was pregnant by someone other than the other party. So, and then there are interim gender recognition certificates, which are more recent.
And these are all things.
These are called voidable.
So if any of these things exist at the time of the marriage,
yes,
the marriage is voidable.
Yes, you can bring it to an end.
So what's the contrast? What makes a marriage void?
Void, bigamy,
right?
Polygamy, a prohibited relationship, which will be sibling or father-child, mother-child, prohibited for that reason. An underage marriage, which was under 16, but after the 27th of February 2023 is now under 18. An invalid foreign marriage, which presumably means all sorts of things. Failure to follow the formalities. And then there are the saddest really are the ones where you go through a religious ceremony, think you're married, but actually you're not because all the boxes haven't been ticked and so on. And they're often the ones that are most concerning, where people think they're married, and they're the ones where they have no ability to make any financial claim. So weirdly, for a voidable or a void marriage, then people can still make financial claims, even though if it was a void marriage, it didn't exist.
So you mean, by financial claims, you mean within like a matrimony, like a divorce case, or
regime, you can still bring a claim.
So well, that makes sense. So you mean if it's a voidable marriage?
Does it make sense? I mean,
yes, because if it's voidable, there is a marriage, but there is an election as to whether or not to annul it.
You're right, I agree with you, for voidable. But for a void marriage, it seems even more bizarre.
Oh, so for void marriages, they
can... Bigamy, for example, I've had a case where...
You can still bring a claim.
Yes, where we brought a claim and were successful, even though it was a void marriage. So, going back to the predatory as in, this, I imagine this young carer, male or female, may have, in a way, maybe someone who's given the elderly person who's died 10 years of actually lots of care. So it's never quite straight.
It's blurred lines, isn't it? It's not,
but they could bring a financial claim, and then the family will get together and say, no, that, she didn't know what she was doing, or he didn't know what he was doing, and therefore there's no marriage. So, and there is that sense of you shouldn't be able to benefit from your crimes, for example. So it's a sort of moral crime to trick someone into getting married. But it's incredibly complicated. I'm going to do more research on it.
It is very complicated, and another reason that it is complicated, linked to what you're talking about, is that I think, as I mentioned, capacity to marry is a test under the Mental Capacity Act, and that those types of capacity decisions, whether or not somebody has capacity under that test, is time and decision specific. So in order to determine whether or not somebody had capacity at the time they got married, in order to prove that it's a voidable marriage and therefore should be annulled or not be annulled, you need some evidence about what they were behaving like at the time and date of the marriage.
Literally, or the hour.
Exactly. And who knows that other than...
the registrar, hopefully.
Well, actually, registrars, it's interesting. So there's quite a lot of talk around this topic about what responsibility falls to registrars, actually, in terms of how much they ought to be questioning whether people approaching them, particularly where you have a big age gap between them, or it's a very elderly person on one side, whether registrars should be expected to ask a lot more questions than I believe they have to at the moment.
You can see why they don't want to. This loved up couple are in front of them, and it just, they want to say, hope you have a lovely life and we all family. You can see why it's quite awkward to say, why would you want to marry him or her?
I mean, I'm not sure how it worked. Did they have sort of pre-marriage meetings?
Yes,
they do.
They have a pre-marriage meeting, and I'm going to find out more about this, but there's a marriage investigation compliance visit that the registrar makes if he or she has concerns about whether they should be getting married. And if the registrar suspects mental incapacity, they should inform the General Register Office. But, of course, as Nicholas Mostyn says, the wisdom of a marriage is irrelevant. So it's not for them
to say, why on earth are you marrying that?
Yeah, and it's not always easy, like that case that we were talking about, which has, I think, prompted quite, the potential change in the law. But with a 91-year-old who had severe dementia, who was married to a man in his 60s, who her whole family said she didn't have a clue, but he managed to get her along in front of the registrar, who said afterwards, no, I didn't think she lacked capacity. I thought she could get married. So they're not doctors, they're not, psychiatrists.
Yeah.
So it's quite difficult.
And it's how much should we burden them with that responsibility? It's very, very tricky. That was the Joan Blass case, and I mean, it really is a particularly sort of heartbreaking story.
Case,
because she there's recollections of her sort of saying, well, where did this guy come from? Did you get him for me? Type thing. Just very confused about what the situation was. And then he managed to stay married to her after she died. He inherited the whole estate. And also
was challenged,
and
obviously.
Also wouldn't engage with the family about sort of burial, and he buried her in an unmarked grave. So it's just really unpleasant.
And he also lived in a house. I think they built her a house, or they sort of shared the land, and the children were in a house and she was in another house. He then was sort of waving at them over the fence,
on
and
the
there
family
was
property.
nothing they could do. It. So
terrible.
It is,
and to be fair, it has been her daughter, Daphne Franks, I think, who has pushed very hard for legislative change. And this now answers your question. And because the Law Commission has finally last year recommended that this provision that marriage revokes a will be revoked itself. So we are hoping, I think there's a wills bill out there in the ether somewhere which includes it. So I don't think we've got any particular information on when it's expected that will come into force, but there's quite a lot of wide-ranging changes that they're trying to do about wills generally because of the age of the Wills Act that we currently rely on, which is 18 something or something, so it does need updating.
Quite new compared with a lot of our laws.
It's true. It's very edgy and modern.
1820. I mean, that I was reading you about, with the fact that in brief you can be old, you don't have to consummate a marriage, you're just there for the
just because you're too old
and the love. And it was a sweet quote, but it all goes back hundreds of years, which is what's quite interesting.
Which I think is what the problem is, that because it's all sort of come from different places and is so historic that there was never intended that everything would sort of meet in the middle in a way that allowed people to exploit people in this manner. And yet the issue has obviously been, front and centre of a lot of campaigning for a while. And we, this wheels are turning very slowly to do something about it.
But it's all on the spectrum, isn't it? When is a marriage exploitative and when isn't it? You know, when you could marry someone for their money, and people do. You could marry someone because you want them to look after you because you're a bit past it. You can marry because you're desperate to have children, you're a woman and you're 39. You know, so it's...
But I think that...
I know, I appreciate that there is a you know, we're talking about extremes, but there's so much in the middle. It's one of the reasons why governments run a mile before they ever try and deal with family stuff, because they know they're going to alienate as many people as they're going to please.
Well, for now, obviously, it remains a problem. I think in terms of if anybody out there is facing this sort of problem for somebody in their family, you know, it depends where you are in the stages, what you can do. If you don't think that they've got married yet, I think you can actually put sort of caveats against marriages at registries in the same way you can against a will.
So you suspect your father is, you know, being taken advantage of, and you can pop round and warn the registrar.
But you sort of put it on the registry so that if that name then comes up as somebody that they're notified that potentially there's an issue, and hopefully then they would look into it in a bit more detail. Obviously that's only for sort of the registrar's service, so you'd have to sort of individually notify churches. Although, to be fair, marriages of this nature don't tend to be big church weddings. They're not going to have the banns read in the same way. So there are sort of options along those lines if you don't. In fact, I think there was a recent case, because another thing that you can do is apply for a forced marriage prevention order or something to that effect if you get in before the marriage has taken place. And there's been a case where somebody actually managed to get this for their parent quite recently. I'll have to look up exactly when it was.
We need to have a follow-up.
But they were able to get that. So you need the Court of Protection to agree that the person, you know, that you're trying to protect doesn't have capacity to decide to get married. So you need the Court of Protection involved, but also the civil courts to make this order that says, 1, you can't marry them, 2, you normally stay away from them. So there'd be a kind of like injunction against them spending too much time, getting too close to them or spending time with them, etc.
That is so sensitive.
It's very severe, but isn't it? So you can imagine the level of the evidence you would need to present to get that sort of order. I imagine it must have been quite a stark case.
And registrars, obviously, when I tried to, I didn't spend enough time on it probably, when I was looking up registrars' obligations, most of them seem to be sort of sham marriages, and they seem to be mainly where you're trying to get immigration status, and that seemed to be, and most of it was on that. There was very little on, you know, old woman being
exploited
by young
so they're not really looking out for it. I mean, query how often it happens, but we have got an aging population. There are more and more dementia diagnoses,
people living on their own,
and higher value estates. So you know, it makes sense that it would be a rising area of criminal activity, frankly. I mean,
well, yes.
You can. It can be a criminal activity.
Very difficult to prove.
Anyway, so yes, if you can catch this happening before a marriage has taken place, that is definitely the best. If not, it is very difficult. If the individual is still alive, then you may be able to apply, but they don't have capacity to make a new will to reinstate what they've revoked by engaging in this marriage. Then there is an option to apply to the Court of Protection for a statutory will, but obviously that might not exactly reflect the will that they had previously, because the Court of Protection is only concerned to do what's in the best interests of this person now. So it may be that something different is the best thing for them right now, but at least it may not be giving it to this nasty person that's come along to steal them.
And don't use this as a don't think this is a sort of way of preventing your naive 18-year-old daughter marrying the nasty piece of work.
Yeah.
that she's been seeing.
No, that's absolutely not the case. You need to show that she doesn't have capacity, and you would need to consult them as well. I mean, that, as you say, blurred lines, etc. If the person with lack of capacity still really enjoys the company of this person and thinks they do want to marry them, then those are opinions that will be taken into account in the court of protection. So it's tricky. But if they have got married and they have subsequently died, I mean, you can't then annul the marriage, can you?
You can't void it once they're dead.
So that's the hardest. You're left with a sort of trying to do a 1975 Act claim against the estate to try and claw some back from the new spouse. I think that's probably the only option.
Bags of work for us then.
Yeah. So give us a call. All right. Well, it has, as ever, been a pleasure to talk to you, Philippa.
It's been a pleasure to talk to you, Samara. It's been really good fun in a sad way.
Thanks for joining us today, and catch us next time.